Hi everyone, today we are going to talk about bail in India. I will explain what bail is and how you can get bail. We'll keep it very simple. First, let's explain what bail means. Bail is a legal permission. It allows a person who has been arrested to stay out of jail while the case is happening. When the police arrest someone, that person may go to jail. But if the court gives bail, the person can go home until the trial or hearing finishes. It is like temporary freedom. We need bail because the law says you are innocent until proven guilty. You should not stay in jail just because you are accused. The trial may take a long time. The court gives bail to protect a person's freedom when the offense is not very serious. But some cases are serious and bail may be harder to get. On screen text. There are two main types of bail in India. 1. Anticipatory bail. 2. Regular bail. Anticipatory bail is when you ask for bail before the police arrest you. This is useful if you think you might get arrested. Regular bail is when you ask for bail after you are already arrested. Anticipatory bail means you ask the court for protection before arrest. This is helpful if someone may file a false case against you. You go to the High Court or Session Court. You file an application asking for anticipatory bail. If the court gives it, the police cannot arrest you for that case. You can apply for anticipatory bail when you fear arrest. You must have good reasons for the fear. The court will check if there is a real fear of arrest, if you will flee the law, if you will influence witnesses, if you will repeat the offense. If the court is satisfied, it may grant anticipatory bail. The court may give anticipatory bail with conditions. These may include things like you must cooperate with police. You must not leave the area without permission. You must not disturb witnesses. You must appear in court when asked. If you break conditions, the court can cancel your bail. Regular bail happens after you are arrested. When the police catch you, you go to jail. Then you apply for bail from the court. The court may give bail, rejecting bail, or set conditions. Every case is different. Regular bail can be given by the magistrate's court and the sessions court. It depends on the case type. If the police arrest you, you apply to the court where you are presented after arrest. That court will consider your bail. When a court gives bail, it looks at many things. These include 1. Nature of the offense. How serious is the crime? 2. Evidence level. Does the police have strong proof? 3. Character of accused. Are you a first-time offender? 4. Previous record. Do you have past criminal cases? 5. Fear of tampering evidence. Will you influence witnesses? 6. Fear of fleeing. Will you escape from the law? The court balances these to decide if bail is fair. In some cases, bail is harder to get, especially in serious crimes. For example, murder cases, rape cases, terrorism cases, crimes with big punishment. In such cases, the court is careful before giving bail. Sometimes courts follow judicial trends. For example, if a court sees many similar bail cases before, it may use that experience to decide. If people don't show up for hearing, the court may refuse bail. If the police warn the court, that affects the decision. To apply for bail, you need to file a petition. For regular bail, usually the police or your lawyer files it in court. For anticipatory bail, your lawyer files it in High Court or Sessions Court. You attach documents, reasons, and evidence. The court lists it for hearing. When the court hears the bail application, both sides speak. Your lawyer explains why you deserve bail. The public prosecutor explains why you should not get bail. The court listens to both sides. Then the judge decides whether to grant bail or not. If the court refuses bail, you can appeal. You can go to a higher court. For example, if a magistrate refused bail, you can go to Sessions Court. If Sessions Court refuses, you can go to High Court or Supreme Court. This gives another chance to argue your case. When the court gives bail, it may set conditions. These conditions are rules you must follow. If you break them, your bail may be cancelled. Common conditions include you must not leave the city. You must report to police. You must not disturb witnesses. Follow these rules. For economic or financial crimes, courts check if the accused will destroy evidence. They also check if the accused will flee. Courts are careful with such cases, but if the accused cooperates and does not pose risk, courts may still grant bail. In many cases, courts are more open to granting bail if the accused is a woman or a minor. The law considers vulnerability, character, and risk. This is not automatic, but it plays a role in the court's decision. Getting bail is not always easy. A criminal lawyer can help you. They know how to prepare the petition. They know how to argue in court. This increases your chance of getting bail. So always consult a good lawyer. Let's quickly recap. Bail means temporary freedom. There are two types, anticipatory and regular. Anticipatory bail is before arrest. Regular bail is after arrest. The court looks at many factors before granting bail. You can appeal if bail is refused. Thanks for watching. If you want more simple legal videos, we are here to explain the law in easy words.